And it is. And welcome to the Fearless Floyd Show, because I am your host, Fearless Floyd. As always, I want to thank you for joining us on this fabulous, beautiful, sunny, warm, almost hot Thursday afternoon, August 25th, 2022. Date. Uh, Thank you for joining us. This is part three of the Ann LeFlore on trusts video series. Don't know how many we're going. She's already got number 4 in the can. It'll be presented probably tomorrow or Saturday. I have to work tomorrow, so we may do it tomorrow evening. I don't know. That may give you all a day to catch up on 1, 2, and 3. So, if you like the video, the topic, me, my guest, subject matter, hit that like button, leave a comment below, subscribe to the channel, hit the notification bell so you know when we put out more videos like this in this series, and share this video with God and everybody. Fearless Floyd Show on Telegram, Rumble, BitChute, YouTube, fearlessfloydshow.com, and you can email me at thefearlessfloydshow@yahoo.com. And with that, we should be good to go. I still have laptop issues. I did get my laptop back, and it does not have Bluetooth, or it doesn't have a network adapter, so I don't have Bluetooth or Wi-Fi. I have to buy a dongle. I only have 2 inputs, so my mic goes in one, the dongle goes in the other. My Bluetooth mouth does not work, or neither does the dongle because I don't have another insert for it. Off to Kentucky you go, laptop again for probably another 2 weeks. Yeah, I'm so looking forward to that. And I'm waiting on Ann to jump on. So until she does, I'm going to pause the video and I'll resume once she gets back on, and we can dive into part 3, kids. 3. No, I'm messing with you. Oh, I do have some good news. In Texas, they have what's called compassionate use for medical marijuana. Can't go buy it and smoke it. They do have gummy, edibles, and tinctures. That's it right there. And there's specific ailments that you are required to have that are bona fide. I have an appointment next week with the doctor to get my ding, 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 passionate use. They don't have medical marijuana cards here. They will. Eventually they will. And looking forward to that. Stress I go through, Jesus Christ, can't wait. So I want to let you know that that's a thing here in Texas. So anybody that has any one of the qualifying ailments, you're eligible. And I found a really good deal. $99 for the doctor's visit. That's it for a whole year. And that includes all your follow-ups. So if you need to know who that doctor is, let me know. Hit me a DM, leave a comment below, whatever. Email me, Telegram. I'll hook you up with that doctor here in Houston. And it's a telemed, so you can actually be in another locale or jurisdiction in Texas for that to take place. That's the smokingest deal I found yet. Most of them are 200 plus, and then they add on to that. That's done, and then there's just Google Texas dispensaries, and you'll see all the dispensaries that are available, what they have available, and how much it costs. And from there, you're good to go. So let me pause this while we wait on Ann to jump in. And we're back, everybody. And I'd like to present the illustrious Ann LeFlore, and we're going to go through part 3 of Ann LeFlore on trusts. Let me get my screen share going, and we're going to start this PowerPoint presentation. And I believe, if I remember correctly, this is 18 panels that we're going to go through our PowerPoint pages. So here you go.
Okay, so today we're going to understand what the different kinds of trust are. So we've already gone through what trusts are, how they're created, how they're different types of trust, but nobody really understands the difference between one trust and another trust. So today we're going to start breaking down what different kinds of trust we have the option to create.
All right, kids, get ready. Panel 2.
So in lawyers' law dictionaries, this one you can find online. And I've given you the link right here. It's from Cornell. It's an online dictionary, and it gives us terms and usages in the law dictionary to explain what all of these are. This PowerPoint document is done through that online dictionary to break down the words, and some of the other reference books that I've used, I've placed them on here, like Graham Morfitt, Trust Law, Oxford's Equities and Trust, Probate Court Laws, William Adams Dictionary of Law. These are just some of the references, a few of the references. There's probably about 25 or 30 other books that I have that I've been going through. And this is just some of what we're going to use today through these books to understand what trusts are.
Okay. Well, that was sweet of you to put some references in here. I'll leave that for just a second. And y'all screenshot that or write those down. And moving on to panel 3.
Okay, so we hear so much about express trust. An express trust is an international trust. It's any trust created voluntarily by a settlor. It can either be private or public. So let's break that down. This is important to understand. If you create an express trust, it's considered an international trust. You have the right to create this type of trust, especially in a court case, against a foreclosure, a collection agency, or a company trying to shut off your accounts. So basically, a trust is created between two people. So you have to have two people in order to create the trust. And that's what creates the express trust.
All right, kids. Public and private. Remember that. Here's panel 4.
Okay, implied trust. The definition of an implied trust is a trust which is equal to a legal agreement in which someone is given control over another person's money or property. Property meaning you. That in the court decides it was someone's intention to create, although it was not clearly stated. So because you walk into the court, you have not created the trust. The court believes you're implying that you want to create this trust. So the court takes it upon itself to create the trust for you. So each time there's a court case or you sign a document, it will create an implied trust. Because you do not create your own trust, the court can create the trust by the signature you placed on the document, which creates the implied trust.
Okay, so basically every time you sign a reset form, any form they put in front of you and you sign, you're creating another trust, correct?
Correct. Your signature is all they care about, because your signature allows them to do what they want to do with it, open up different trusts, which every single trust has 2 to 3 to 4 bonds on each trust. So this is where it becomes complicated. They don't care about the trust. The trust, maybe will pay the electric bill. All they care about is the bonds that are with those trusts. And that's what they want. They want access to the bonds. Like I said, everything comes back to bonds and trust.
Money, 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 money.
Yeah.
All right. And we are moving on to Panel 5.
You got it a little bit large for me to go through this one.
Okay, let me bump it down a little bit. How's that?
Yeah, that's better.
Okay.
Okay, so trust intent. Trust intent is a settlers. You're the settler. Intent to make a trust. It is a requirement of an express trust along with trust property, a trustee, and a definition of a beneficiary or a definite beneficiary. So a trust intent means that you have the intent once you receive the offer to create this trust, which is the express trust. So you have to literally express your intent in court. And the intent of the trust is important. As the grantor or even the settler in a debt or a court case, it is your right. You do have a right to create the intent of the trust. So as long as you can prove the elements such as express trust or trust property, the trustee is the beneficiary, you can create the intent of a trust.
Get that? As long as you can prove the elements, such as an express trust, the trust property, trustees, and the beneficiaries you can create is a trust intent. So we're going to get all this. And again, please be patient, kids. I understand y'all want to get out there and run, but if you don't have all the tools, you're going to get out there and run and you're going to fall down and you're going to be running with scissors and probably hurt yourself. Please be patient.
Also keep in mind, guys, people have been at this for 40 years and they're still in the learning process. You see, we're not lawyers. When all of these documents were originally created in the 1700s, when the Pilgrims came to the United States, they were all just simple people like us. They had no idea how to write a document, create a trust, or anything. That's where the esquires came in. So you see, esquires and lawyers have always been at this since the very beginning. This was their system. This is what they created. So it's the only thing we need to do now is understand it. Get it. We're not lawyers. We don't want to be a lawyer because we don't want to deal with it. But we need to learn the process and the procedure, and we need to learn it correctly. And it's just not one person to follow. I'm not saying I have every single answer you guys want, but I can teach you how you can find your answers.
Exactly. Now, she says, Ann says to learn this. Well, you can learn it, but you want to master it. So you don't have to reach out, ask questions, hit a stumbling block, and not be able to move forward. Or if you're in a certain situation and not know what to do, to where you kind of back off because you just don't know the right answer. Most people will try to, plow through it and give the wrong answers, and that's not what we're looking for. So with this video series, this is to teach you, and we're going to try to cover every scenario that you may encounter. And I would likely say we're not going to be able to do all of them, but we're going to try to get the majority of them. So when you do get out there and you do meet these persons that you're going to encounter trying to effectuate these different processes for all the many different things that this covers, you'll be totally prepared. You'll be a Boy Scout. You'll be prepared. That's their motto. Unfortunately, I was kicked out of the Boy Scouts. Imagine that. No surprise there. Kicked out of Mexico, kicked off a prison unit, kicked out of the Boy Scout. Yeah, it just goes on and on and on and on. Yeah. God damn, I was
Rebels always get kicked out of everything.
Everything. Jesus Christ. I was that kid. Okay, panel number 6.
So was I.
All right.
Okay, so now we're going to understand what trust property is. Trust property is also known as trust res. Somebody put down trust res, R-E-Z. It's incorrect. It's R-E-S. Okay, which is the trust corpus. Okay, what is trust corpus? Body. That's what corpus means. That's the translation of corpus. It is the property that is subject to the trust. The property must be presented, presently existing and identified inside the trust. Trust property can be any property in interest that the law recognizes as a valid property interest that can be transferred. It's a requirement in an express trust along with trust interest, a trustee, and a definite beneficiary. So what is this saying? We already went over that trust res is a thing. It has no value. It's an offer. It's a court case. It's a offer that arrives in the mail, such as an electricity bill to pay, a loan document, some type of an offer. You go to buy a new car. You're presented with a contract. The contract is an offer. Once you sign it, you receive the paperwork, you receive their offer. So this is all really important. All of this is considered trust property because we can move them into the trust and create the trust res, which also creates the special res or the property res that we can use to pay the debt with our credit.
Okay, on that particular topic, this is what I have. Got me a little red snow. Let me turn on my camera. Man, it's so difficult not having a mouse. A little red stamp says received. And then I have the little stamp for dates. And I have a little red ink pad. So whenever I receive something in the mail, I stamp it received and then date it. That's showing them when you accepted it. So now you can, because they sent you the presentment and they're looking for somebody to accept it. And you did that. And there's your proof that you're showing that you did accept it. And
yep, they sent you the offer. That's the offer.
Yep. So you can probably get these little stamps. Trodot is a one of the major stamp manufacturers. They don't actually make the stamp pad that actually imprints what your information, but that's the one who makes the actual stamp itself. I have Rubber Stamp Champ. That's a good one to use. If you're going to order those off Amazon, man, I went through that circus, and it got to the point where they were sending me stuff that wasn't even nothing near what I ordered, and I got a bunch of free stuff that I can't even use because they were like, "Don't even send it back." Okay.
When I was in San Diego, I did see those at Office Depot.
These little received stamps.
Yeah, I saw those at Office Depot because I do believe I did buy one, and it was a square, and it had these little things that you could break off and send put in it to write the words and stuff like that on the stamp. And then you just got the stamp pads. The stamp pads were right next to it. And you can, but that's been, like the last time I was in America was 12 years ago. So don't take my word for it right now.
Right. This is one I ordered off Amazon, and that's my EIN for my trust, no, my estate. You say they put date on it. And that's what I took the date off the bottom. Now it's just my EIN number. This is a self-inking stamp like that. And I had one of these that had my seal on it, and that's what I was ordering, my whole seal with my name, the date of establishment, and all that stuff. And they sent me this piece of garbage.
Guess what? Don't bother. You're going to waste your money.
Yeah.
As an executor of an estate, yeah, as an executor of the state, you do not want a seal. You do not want a thumbprint. You do not want anything but your signature in blue ink.
That's why I did not get another one.
Yeah, you're just wasting your money. And, you know, I see a lot of people who buy the gold seals that are the raised seals and plaster them all over the place. When you're doing that, you guys are just never going to get out of the public. That is always on the public side. That's how the public works. If you want to be on the private side, your signature is the only thing you need to prove. That's it.
And I'm guilty. Guilty as charged.
We all are, because we never really understood the law, because it's pig Latin to me, dog Latin, pig Latin, whatever they want to call it. It's so twisted that you literally have to break down word for word and then just start looking up certain words and getting an idea of how they use that word in order to decipher their code. And once you start understanding their verbiage, the code is easy to read. It's easy to decipher. It's just like writing a computer program. Once you understand the ones and the zeros and what, you know, the 8-bit, you know, means, then it's pretty easy to go forward.
Yeah, just learning how to put together a legal vehicle, whether that's a motion, a writ, petition, affidavit, you know, a brief in a coherent, legal formal way. Years and years and years of learning. That's even if you have, you know, somebody that you can rely on who knows what they're doing to kind of guide you. Because it didn't come easy for me. By the time I got it down to where I could just write a smoking brief, probably took me, Jesus, 5-6 years.
Don't ask me to write one. I have no idea.
Yeah. I mean, you know, I put my writ of habeas corpus together, and in hindsight, I'd have done it different. But as it stands, it was, yeah. I'm going to get them to put it online. And that way everybody can actually go look at it if you don't want that much time. So that way I can print it out. It's only $5 to put it online, and then I can print out as many copies as I want, or I can go down there and pay $1 per page to have them copy it. That's crazy, huh? All right. Panel 7.
Okay, so a definite trust beneficiary. So we need to know who the beneficiary is. And this is a requirement in an express trust. You can't have a trust without the beneficiary. So it has to be named. That's what it means defined. It means to name it. That's basically it. You know, and you have to also go along and name the trust property, the trust intent, and the trustees. That completes the trust. Estates are not quite the same. We'll go over estates so that you guys can understand the difference between creating your birth state or your estate, your estate through your birth certificate. And once your estate is created, then how you can create sub-trust. Right now, we're just dealing with trust because they put us in a trust on a daily basis. We're still going to go through and create our estates, and we're going to create our bank accounts, and we're going to file the paperwork. And if you have court cases or you have creditors coming after you, the next one is going to be on how we can rectify that with two letters. So that will be tomorrow's or the next days or whenever we do the next sessions topic.
Right. That's
So, yeah,
part 4 of the video.
right.
Okay.
So
Yeah.
we have to understand, as long as there are objective standards on which we define the parameters of the group of beneficiaries, the trust will not fail for lack of a definite trust beneficiary. So you hear a lot of people say a trust cannot fail for lack of a trustee. It's the same scenario. A trust cannot fail for lack of a beneficiary. If the trust is set up correctly and the beneficiary is not named, or the beneficiary has died and you haven't put a new one in, it cannot fail. So it's the same principle.
Absolutely. I work tomorrow from 11 to 5 at the George R. Brown. So I will be tied up most of the day. So if you're, God, I'll be at 5 o'clock traffic. Well, yeah.
Well, yeah. I mean, maybe we should just do like 3 a week to give people the time to literally do some research and give them time to start learning this.
Okay. I'm dodging.
Or
I'm
do 4 a
dodging.
week.
I'm dodging rotten apples and eggs right now.
However many, I mean, if I mean, 7 a week is kind of, because you have to realize I'm still writing these. It's all in my
I
head.
get it. Yeah, and you have
And yeah, I mean, if I wrote 4 a week or 5 a week, that would be cool.
yeah,
Then we
I'm
can,
good with that.
push it out. And I'm trying to keep them short, so it's easier to, get segments of it.
Yeah, absolutely. Okay. Um, moving on to the next one.
Okay, what is the declaration of the trust? This is a little bit more elaborated. Remember, these are all coming from law books. This is how they define trust. So the declaration of the trust is a document used to establish the primary details of the trust. Okay, so we create our primary details of our trust. We can do that on a piece of paper. I've seen people, sit down and, scribble stuff on napkins and take it home and, oh, here's my primary benefits or my primary thing, and hand it to the lawyer and say, okay, create it for me. So we can do it any way we want. Okay, while some states allow oral declarations, many states require a written declaration of trust, outlining the essential pieces of the trust in order for it to be legally recognized. Declaration generally states who the trustee and beneficiaries are, and they often state how the assets are to be distributed to the beneficiary. Depending on the type of trust, declarations can include a variety of details, like when to end the trust, how to manage the assets, how to replace a trustee. Okay, now here's the key. In England and Wales, a declaration of trust is used as a document certifying the owner or joint ownerships, sometimes instead of creating a trust. That's only in England and Wales. I could not find any laws in America or other states or other countries that this works. So this is just their little court that they allow in England and Wales.
Okay, where everything evolved from anyway.
Right. It comes from there, so they're the ones who created it.
All right. Yeah, barristers. All right, panel 9.
Okay, now here we go, trust corpus. Because every time we create a trust, we create a trust corpus. The term corpus is Latin for body. A trust corpus is the body of the trust. So this is your heart of the trust. This is what it's all about. This is the property that is transferred into the trust, also known as the trust res. A trust corpus is one of the fundamental elements that has to be defined for the formation of a valid trust. A trustee holds the trust corpus for the benefit of others. So you see, we will move these offers into it, create the body or the corpus of the trust, and we will give the judge the corpus, which is the body, and they have to be responsible for it because we're naming them as trustees.
Absolutely. Habeas corpus, bring me the body. All right, panel 10.
Okay, trust protectors. A trust protector is a role with specified duties that are assigned by the trust document in order to fulfill the purpose of the trust. In the Uniform Trust Code, section 808, the trust protector is defined as the person other than a trustee or beneficiary who holds power over some aspect of the trust. Not all states have adopted the Uniform Trust Code, so the trust protector is not deemed to serve as a fiduciary capacity. However, under Delaware law, the trust protector is commonly a fiduciary. The trust protector also has a lot of power, like the power to remove or appoint trustees and advisors, and the power to modify or amend the governing instrument of the trust. We can also look under DGCL Title 12, Chapter 33, Section 3313, number F. So this is what a trust protector is. And in 1863, Abraham Lincoln, I think I put this in here. Yes, the next one. I'll explain it. I think it's the next one.
Okay.
We'll explain trust protectors.
Okay. What does DGCL stand for?
That was just inside the law book. So I didn't really look that one up, I'll be honest with you. Like I said, these are coming from definitions of a law book. So basically what I'm trying to do is just get people understanding the definitions of trust in this one, right, and what the different parts of trust are and how they work. Okay.
It stands for Delaware General Corporation Law.
Oh, good. Thank you.
You're welcome. I missed that when I was proofing it before we got on here, so my bad. But I cleaned it up, got out the broom. All right, panel 11.
Okay, so I was just going about what Abraham Lincoln did. So the 1776 Declaration of Independence, actually the Articles of Confederation are the first one who created the trust indenture for the 13 colonies. And in the trust indenture, they created the trust indenture in 1774 when the Articles of Confederation were first written, and they first declared that they wanted to be free from the government or from European control. So the 13 colonies had individual trusts for the states, which were created by the colonies. And what that meant was the people created the trust. The government or the elected officials were the guardians of the trust, and the people were the beneficiaries, because the people created it because of them being the grantors. So they all came together and they granted the trust, and they granted the people they elected to be the trustees. So in 1863, right when the war was starting, we had major conflicts. All the states were in bankruptcy. None of the 35 states at that time literally were taking care of their trust. They were not standing up, and they were not being the trustees of the trust. So Abraham Lincoln on November stood at Gettysburg and gave the Gettysburg Address, which literally took the 35 trusts and put them into a new trust under the federal government, as the federal government as the trustees of this trust. And What he did is he assigned at that time a trust protector. And that trust protector is still the protector of the trust. It's actually the military. I get a lot of flack with this, people saying, well, Abraham Lincoln couldn't do that because he was an esquire. Okay, what I'm telling them is nobody could have done this, because seriously, nobody knew laws. And the only way any of these documents ever got written was by esquires. So if we look at the Articles of Confederation, esquires wrote them. If we look at the Declaration of Independence, esquires wrote them. If we look at the Constitution, esquires wrote them. If we look at any contract, an esquire wrote it, because they were the only ones who had the schooling or the knowledge to literally create these documents. So if this trust indenture is void and null, then every single document that was ever written for any of us has always been void and null, because it's always been written by an esquire. That's my point.
And if you do your research and find out who generally your state and federal legislative bodies are, they're probably about 75% esquires. For reason.
Mm-hmm.
All right, panel 12.
Okay, so we're going to go into trust instruments. What is the instrument of the trust? A trust instrument is a written declaration or agreement to allocate a settler's property to their beneficiaries. It consists of the trust and regulates how the trust is executed. Trust instruments can be amended or revoked by the settler at any time, but there are some exceptions, like irrevocable trust. There are many types of trust instruments. For a trust to come into force, it should contain a certain form with the necessary elements and get legal recognition, i.e. be recognized by an eligible official authority, which is the court. Okay, so this is just saying, because we're the grantor, we need, and we have the instrument because we're the property. So we have the elements to create the trust. And now we just need a second party to form the trust. And the second party is the person who sends us the offers. Once we can identify all the instruments of the trust, then we have a legal official trust.
There you go. Panel 13.
Okay, so this just keeps going on, and it's going to tell us all the different elements of this trust. So I think it's like 3 pages of it. It's going to explain it to us. So this is going to explain what the instruments inside of the trust are. So your basic elements: beneficiary. A beneficiary is defined and is reasonably ascertained. Natural persons, corporations, or other organizations like charity can all be beneficiaries, but the same person cannot be the sole trustee and the sole beneficiary. So keep that in mind. You cannot be 2 people in a trust. You can be 2 people in a trust, okay? Let me rephrase this. You have 2 positions in the trust. You're the grantor plus the beneficiary, or you're the grantor plus the trustee. You cannot be the grantor, the beneficiary, and the trustee all at the same time. You can only be 2, the grantor because you granted it, and you can only be a beneficiary or a trustee. So you cannot be both. Otherwise, the trust is null and void. It literally freezes the trust if you take on both positions. Does that make sense?
It does to me.
Okay. Settler. A settler should have capability and compensate, and the intent to create a trust with a valid trust purpose. So we have to be competent. Remember, that's why they said they do it for us, because we're incompetent. So we need the competency to create our trust. Okay, what is a trustee? We know what a trustee is. They're the ones liable for everything. So the trustee is authorized by the settlor, which is you, to execute and manage the trust property. So you're in charge of managing that trust property. It's your responsibility. You have the liability to take care of it. A trustee should perform their duties from trust instructions. So you're the one who gives the instructions to the trustee, and he has to follow them. This is what we're going to be going into. This is what we're going to learn how to do. Write your instructions clear, precise. Do not spend 41 or 50 pages to write out a simple instruction. They're not going to read it, guys. You're lucky if they're going to read 2 paragraphs. So you have got to literally go, I want A, the assignment of the offices. A, assignment of offices. Grantor, name. Beneficiary, name. Trustee, name, period. Go on to the next. Responsibilities of office, and just start naming them. And what is the intent? What is the, body corpus? What are your responsibilities? Trustee is responsible for performing A, B, C, D, and cut it off. Do not just keep, going on, 50 pages, because they're going to throw it out, because nobody has time to read it. Nobody. And I get bored reading it.
Right. Yeah. And that's the problem, we have. And to give you a fantastic analogy, hang on one second. Let me take this call. Sharif. I'm doing fine, sir. How's that bank account coming along? Okay. Uh-huh. Yeah, hope so. Okay. Okay. Cool. Okay. All right. Perfect. Okay. Yeah, I get it. Okay. Yep. I'll look forward to it. Have a good weekend if I don't talk to you tomorrow. Thank you, Sharif. Wells Fargo, like going on 2 weeks setting up a trust bank account.
I should send you this super simple letter that all you do is have to send that in, and your account can be created with no time. I think that's what you're missing. You're missing the formation.
Well,
I have it. I have it.
Yeah, they trip out on me every time I go in there anyway. But okay. Yeah,
Yeah.
we'll get to that. All
Yeah.
right. Panel 14.
So here we go. We're continuing on with what is inside the trust, property. And we have formality. So the property is a valid trust instrument, must include property legally owned by the settlor, and it is not created unless the property is received. So an offer is your property because you received it in the mail. Get that. When they send you court documents, it's your property now because you received it. So this is what's important, understanding words and how they're using these words. And it's not a trickery. It's just understanding that these stuff has been written in the 1100s or, before that. And you have to realize how the language is spoken back then. So you sort of have to master the languages. So what it's saying is property can be transferred contemporaneously when the trust instrument is signed, or later, even after the death of the settler. So when we sign the trust instrument, we can transfer the stuff into the trust. Okay, formality to take effect, the trust instrument should comply with the state law requirements. There again, you guys, you're gonna have to check your laws, okay? Every state is different. I cannot, do a document for every 50 states. It would just take too long. And this is part of learning process is, digging into your state codes or just Googling something, Georgia state code, trust laws, or what is the law for, probates or something like that, and just put your name in. I do have some that give all 50 states, but it's for different things. It's not just for, what we're talking about right now.
Good enough. And no, nobody's going to do yours for you. This is what we were talking about the other day. You need to do this stuff yourself so you understand it, you totally comprehend and master what you're trying to do. I can't even imagine you doing 50 states plus the U.S. territories. Oh my God.
I did that with Bonds for the Win.
Yeah, I can imagine what that looked like. All right, here we go.
Yeah, I even wrote 50 FOIA requests, one for each state.
Jesus.
Yeah.
Whoop, I missed one.
Did we miss one?
Nope, this is panel 15. I missed the typo.
Okay. Types of trust. According to the terms of the trust instrument, it can be defined into different types. For example, so this is coming from law, guys. I didn't, put this out. So we have inter vio trust is created when a settler is alive. Here we have a testimonial trust is usually created through the terms of a settler's will or goes into effect after the death of the settler. Revocable trust can be amended or revoked by the settler at any time. Once the settler is dead or incapacitated, it becomes irrevocable. Irrevocable trust cannot be amended or revoked by the settler once implemented. If the trust instrument doesn't state whether the trust is revocable or not, the Uniform Code UCC adopted by the majority of more than 35 jurisdictions, regardless that the trust is revocable by default. However, if the state law says differently, the state law governs. So like I said, you guys are gonna have to look up your state laws, to see what applies to you in which states.
Yep. Gonna have to read. Oh my God. Last but not least, panel 16.
Okay, so trusts basically fall under implied or express. That's it. Okay, it's necessary that we start to express our trust in order to work in equity to pay off our debt. Claiming our estates and becoming executors of our estates allows us to create multiple trusts to handle the equity in our estates. If we do not stand up and express our trust, an implied trust will be created for us. So we never expressed our trust. So we have, I don't know, hundreds of thousands of implied trusts. There is remedies for all these implied trusts, guys. We're going to get into that. So just hold on, learn what trusts are, learn what these different elements of trust are before we move on. So an implied trust can have many executors of the trust that they create. We do not need to modify, we do not need to be notified of these trusts, and we're named as trustee because that's what it says, the law states. if the trust is created or implied because we didn't express our interest in the trust, we don't even have to know it's there, even though we're the grantor of it and we're the trustee of it, but we didn't take any interest in it, so they don't care if they notify us or not. That's it. You have to learn to be who you are.
Yep. And that's going to take a little studying, especially the law in your jurisdiction as it applies to establishing, controlling, and benefiting from trusts. So
one thing I have seen is, like, from state to state, if different states literally put out a law in the statutes, most states will try to adapt, across the board, these statutes, especially in trust and trust laws, so that it sort of is, uniform across the board. And they'll try to stick with the uniform code for trust. So, but some states just don't want to do that. Some states want to create their own. So be careful what state you're in and really do your research and start with that to understand, the different codes.
right, Louisiana is definitely going to be different because they haven't adopted the UCC in whole. They've only adopted it in part. They're the only state to do that. So, all right. Well, we've concluded part 3, and we'll do part 4, I guess, beginning of next week.
Well, if you have time tomorrow after you get off of work or whatever, because I mean, we are a 6-hour difference or 5-hour difference in time. Right. So, I mean, 5 o'clock your time is only noon my time.
Yeah, and I don't have any idea what I'm doing tomorrow. I know I'm rigging, and that could entail driving a scissor lift to a booth and hanging a banner, and I'm done.
Yeah,
that's simple. Or it could be complicated as, hanging a huge light array with props, and I mean, it could be easy, it could be complicated, but I don't know.
So you want to play it by ear?
Yeah, we can play it by ear. It's Friday, 5 o'clock in Houston, Texas. So you're going nowhere fast. So just count on an hour from getting from point A to point B. Yeah, doesn't matter where you are. It's going to take an hour. Yeah, I mean, I'm good till.
Okay, well then let's try to schedule it for Monday because of being Friday, the weekend, and everything else.
Oh, well, I'm good for later. It's your schedule that I'm trying to work around.
Yeah. See, normally I just, like try to end at 5 so that I have some time with my family and, dinner, dogs, everything else.
Yeah, those dogs, man, they need all kind of attention.
Oh yeah. Especially the little lap dogs. They require more than the big ones.
Right. I want to do the mail video whenever you have chance, whenever you have time.
Okay.
Yeah, I mean, you don't have to type anything up for that, right? You already have all that instrumentation.
I don't think I've put one of the mail ones together yet, but I could, that's pretty easy to put together.
Okay, yeah, and you can
how to mail, how to use the stickers to mail, and
okay, yeah, you can email me the information and I can share it, or you can share it on your end. I can give you that authority.
Okay.
Yeah, cool.
Okay, let's just work it out by let's just feel our way through it.
We'll get it. Okay. All right. Well, thank you again very much for your grace, your hospitality, your intelligence, your years of research.
Just remember, I'm not a lawyer, guys. I'm not a lawyer. I am just a teacher.
Yeah. Hopefully you have some willing students. Okay. Thank you. You're free to leave, and I'm going to do my closing spiel as always.
Okay. Sounds good.
All right.
Talk to you later. Okay.
Thank you again, Ann.
Okay. Bye-bye.
And there you have it, kids. Part 3 in the can, out on the streets. I know sometimes I just have too much fun with myself. So I hope you enjoyed that. I hope you liked this video, because if you did, you need to hit that like button. If you want to view more material, or parts 1, 2, 4, 5, possibly 6, possibly 7, I don't know how long this video series is going to go, subscribe to my channel. Hit that notification bell so when we put out more videos like this one, you'll get notified, hopefully, because I am being suppressed by you know who. Absolutely. Share this video with anybody you want. Leave a comment below. Come hook up with us on Telegram. FearlessFloydShow.com, FearlessFloydShow@yahoo.com if you want to email me. Thank you for hanging out. Thank you for taking the time to watch this video. I really do appreciate each and every one of you. I know Ann does as well. And we look forward to walking you through all these videos. And then we're going to walk you through completion of your instruments so you can start effectuating your trust and taking over the authority of your accounts that we all have abandoned. And as you see through these videos, whenever I've made a mistake, I've made an error, I stand up and I acknowledge it, that, hey, I did that, my bad. I am guilty of certain things, and I do take responsibility for my own actions and words, as well as you should too. So with that, thank you for watching. I hope if I don't talk to you guys before the weekend, hey, have a safe and happy weekend. I know Labor Day is coming up, and school's starting, all that stuff. So be careful out there, and stay away from monkeys, because you don't want to catch monkeypox, right? All right, kids. Y'all have a good one. Thank you for watching.